the allegation here, and this is the heart of the Code of Ethics, is that a public official can't take an official action if it will cause an economic impact on himself, family member, or business associate. What the allegation was not, and what is not part of that section of the code, it wasn't an allegation of bribery. This is a very important distinction that everyone has to understand. It was never alleged that Senator Irons met with his business associate and came up with a quid pro quo arrangement. I will give you brokerage fees if you kill pharmacy freedom of choice legislation. That's bribery. That's a violation of the criminal code. It's still a violation of the Code of Ethics. And bribery is always illegal. This really highlights the importance of the Ethics Commission in that that's not really what we look at. Bribery isn't the same as a conflict of interest. Bribery is always going to be illegal. But conflicts of interest, it's a lesser standard. We don't look into whether there was a quid pro quo, whether you had an illicit arrangement with someone to vote a certain way or introduce certain legislation. It's simply enough that you've got this relationship and you take official action as part of your public duties that economically impacts them. And that relationship could be a business association, it could be a family member. You shouldn't introduce legislation to financially benefit your sister. It doesn't matter whether or not you and your sister had an agreement that you get a better Christmas present next year in return for you introducing that. And so I know we're going to get in later into what is left of the Ethics Commission's jurisdiction, but I felt that it's important to make sure that we all understand that this is the thing that we lost, the ability to go after this use of position provision just with respect to members of the General Assembly. We can still go after, I don't like to say go after, but we still have clear jurisdiction over all other public officials for that key conflict of interest provision.
Thank you. Now we're going to hear from three different people giving their perspective on this decision. And I think we have three quite different points of view. First, we'll hear from Tom Bender, who's an appellate lawyer and a partner in the law firm of Hanson Kern LLP in Providence. He has litigated appeals in the Rhode Island Supreme Court for the last 20 years and has published several law review articles on state constitutional law issues, and he wrote the Friend of the Court brief for Common Cause. Then we'll hear from Mark Friel, who's a partner in the firm of Edwards, Angel, Palmer, and Dodge, where he's been a practicing attorney for 21 years. Mark has been a longtime cooperating attorney for the Rhode Island affiliate of the ACLU, and he filed the Friend of the Court brief on behalf of the ACLU in this case. And finally, we'll hear from Barbara Binder, who was appointed, who is chairman or chairwoman of the Ethics Commission. She was appointed to the commission by Governor Kachiri and has served as its vice chair and is now the chairwoman. She's a lawyer by training and has worked in both the public and private sectors. She served as Deputy Chief of Legal Services for the Department of Business Regulation and then as Chief of Staff for General Treasurer Nancy Mayer. She's been on the Ethics Commission for the past 5 years. So I'm asking each of them to talk for about 5 minutes about the opinion itself, and then we'll move to questions from the audience. Mr. Bender.
Thank you. Good evening. I also am a board member of Common Cause, and I just wanted to clarify that all my comments here tonight are mine alone. They're not comments that we have been vetted through Common Cause or should be attributed to Common Cause. They're mine alone based on my review of the opinion. And I'm not going to really talk about speech and debate tonight because that issue has been decided by the court. The court has determined that the Ethics Commission does not have jurisdiction to question the core legislative activities of people in the General Assembly. That means whether they're proposing, debating, or passing or voting on legislation. But since this was about the effect of the Irons decision on the Ethics Commission, I wanted to talk about 2 aspects of the decision that could have an impact on the Ethics Commission in the future. They weren't decisions or rulings made by the court, but they're parts of the decision that I think reflect the court's attitude towards, or at least the majority's attitudes towards the current way that the Ethics Commission operates and some of the rules around that. The first and easiest one is with respect to the right to jury trial. Now, as Jason said, Judge Darrigan denied Senator Irons' motion in the lower court. But in the Supreme Court, the majority did not reach that issue because they didn't have to. Once they decided that the speech and debate clause applied and Mr. Irons could not be prosecuted, then they did not have to reach the constitutional issue that he raised as to whether or not the state constitution required that he have an opportunity for a jury trial on these ethics charges. But in not answering the question and in saying that they would not address the question, they indicated that they thought that it was a, quote, formidable argument. Now, I suggest to you that that's a virtual invitation to anyone who is being prosecuted by the Ethics Commission to reprise that argument again. The Supreme Court, for some reason, the majority felt that they needed to advise the world that they thought pretty highly of the jury trial argument. And that jury trial argument has a very wide impact, because that wouldn't just be limited to legislators. That would be limited to anybody. I mean, that would apply to anybody. That would apply to the governor. That would apply to the Secretary of State. It would apply to a member of a local municipal board who was being prosecuted by the Ethics Commission. And it would present the issue that, as Irons argued, that he was entitled to have a jury trial, meaning that instead of the Ethics Commission being the finder of fact as to whether or not a violation occurred, it would have to be a jury of 6 or 12 people that would determine that. That is something that I think you will eventually see in the future, because any lawyer worth his salt who reads this opinion and is representing somebody who's been being prosecuted by the Ethics Commission almost has to raise that argument, the argument that was raised by Irons here, because the Supreme Court has, the majority anyway, has indicated that they thought that it might be a pretty good idea, a good argument. I don't personally happen to agree with that. I think that the Constitution itself provides that the Ethics Commission has adjudicatory power, but in any event, the Supreme Court has indicated that they think that that's a pretty good argument, and I think that you're going to see it again. The second aspect of the decision that I found a little bit concerning is with respect to the footnotes in there. The footnotes in this opinion are incredibly important, and in particular footnote number 15, because in that footnote, in order to reach the decision that they did, the Supreme Court had to they had to deal with the 1992 advisory opinion that was issued by the then members of the court regarding the authority of the Ethics Commission to enact substantive laws on its own. In the 1992 advisory, the issue was whether or not the General Assembly had to pass a law, and then the Ethics Commission could only enact a regulation that was consistent with that law. In other words, they had to follow the General Assembly's lead. The Ethics Commission took the position at that time that no, we could enact our own regulations. We have primary authority over substantive ethics laws in Rhode Island. And in that advisory opinion, the justices agreed with that position. So since 1992, the constitutional position has been that the Ethics Commission has primary jurisdiction over enacting substantive legislation, that is regulations with regard to ethics laws, which is a very unique position for an agency to be in the United States. But they have a primary authority, and that the General Assembly can enact ethics laws, but they can't be inconsistent with what the Ethics Commission does. Now, in reaching that decision, they adopted this implied repeal argument. In other words, the General Assembly under the Constitution has the power to enact law. And by what the court essentially did in that opinion was to determine that the adoption of the Ethics Amendment in 1986 impliedly repealed a portion of that power without saying so explicitly. Well, they had to, in the Irons decision, that was essentially the argument that the Ethics Commission and those supporting the Ethics Commission were making, that the adoption of the Ethics Amendment impliedly repealed the speech and debate clause when it came to the jurisdiction of the Ethics Commission, and the court rejected that.